We had some attendees in the waiting room. Let's wait for them to filter in here before we get started. Giving it a minute or two here to let people filter in. All right, well, let's go ahead and get started. I'm sure we'll have some people joining us. The lunch hour is always a tough one. So anyway, welcome to today's webinar. I'm Sarah Miller. I'm the Vice President of Communications at the Small Business Association of Michigan. And I'm excited to welcome our friends from the American Arbitration Association today for this informative webinar. I'll soon turn it over to Catherine Glody to kick everything off, but a couple of housekeeping items. One, today's webinar is being recorded and we will provide it to you after the fact. It'll also be available on our website. We don't know if we'll have time for questions, but if you do have questions, you can feel free to put them in the chat. And if we have time, we'll get to them at the end. So thanks again for tuning in, and I'll turn it over to Catherine.
Thank you so much, Sarah. Welcome everyone to today's webinar entitled, Is an Arbitration Clause a Good Fit for Your Business? I am joined here with Sherry Cataldo. She's one of our panelists, and I'm going to tell you all about her in just a moment. My name is Catherine Glody. I'm the new Regional Vice President based in the Chicago office. I'm also a former litigator and also a former panelist. I'm joined here today with Sherry. She's a Michigan-based trial attorney and a business lawyer with more than 33 years of practice. She's a former member of her firm's board of directors. Her practice focuses on complex business and commercial litigation with an emphasis in matters involving partnership, shareholder, and member rights, contractual disputes, real estate, finance, employment, and unfair competition. She also represents life, health, and disability insurers across the nation and is actively involved in alternative dispute resolution. Today it's a long series of words, so we're just going to call it ADR for purposes of today's webinar. So Sherry is also a circuit court certified mediator and of course, one of our featured panelists. So with that, we are going to dive into our webinar, but just an initial disclaimer. Sherry and I are not giving anyone legal advice today. Please consult your counsel if you have questions about whether an arbitration clause is the right fit for your business. But with that said, Sherry, thanks so much for participating in today's program. Welcome. And can you tell us all a little bit more about why this is an important topic for you?
Sure. First of all, thank you for the introduction. I'm happy to be here today. I want to start by giving you a couple statistics that I found interesting as I was preparing for this webinar today. Something that you out there may already know is the Small Business Association of Michigan defines small business as fewer than 500 employees and having an annual gross revenue equal to or less than $25 million. So this accounts for 99.6% of all businesses in Michigan. That was news to me, frankly. But what you may not know is that business litigation impacts 36 to 53% of small businesses every year. That's according to the zebra.com, which is an insurance website you might be familiar with. 45% of small businesses are currently in litigation, and 90% of small businesses will experience a lawsuit at some point. Those are sobering facts, I know, but what it can be learned from that is be prepared, be proactive. Decide in advance whether you want to resolve your dispute in court or in arbitration. When, and not if, except for that lucky 10% of you experience a lawsuit. So, Catherine, to get back to your question, why is this important to me? Is that having been in business litigation for much of my career and specializing as a business arbitrator the last several years, I have seen how being proactive increases the satisfaction of the parties with the outcome, whatever that outcome may be. And that's my goal. That's what's important to me. And that's why this topic is so important to me.
Thank you, Sherry. And I'm just going to zoom out for a moment because our audience, what is AAA? What is ADR more generally? So I just want people to lay that foundation very quickly. So it's an alternative court system, essentially. And AAA is one of, perhaps the largest and the oldest provider. It's been around for over 100 years. And by AAA, I mean American Arbitration Association. So what Sherry and I are saying is that if you have a contract, for example, with a vendor, you can decide ahead of time in that contract. You can say, if there's no language, you may end up in the traditional court system. But if you all plan in advance and put some clauses in your contract, you can opt for a private court system, and you can specify American Arbitration Association as your preferred provider for those services. And we'll talk about it in a minute here. Clause Builder, you can incorporate mediation pieces. You could get specific. You could talk about discovery and other things. But sometimes it surprises me how many people are like, what is arbitration? How, there's a private court system? Yes. And it's international. And you'd be surprised, if you look carefully, if you bought a washer, dryer, a warranty, look at that fine print. You may see a reference to an arbitration clause. They're becoming increasingly common. So with that said, Sherry, what should a small business owner consider in deciding if an arbitration clause is right for their business?
Okay, so the first thing that I would encourage you to think about is whether the preservation of the relationship with the party you're currently in a dispute with is important to you. Because remember, your dispute, it might be with a consumer, it might be with a vendor, it might be with an employee or another business. So arbitration can often serve to better resolve those disputes while maintaining the relationship. And the reason for that is it tends to be less adversarial and less formal. So for those of you that haven't participated in an arbitration, let me just tell you that typically an arbitration takes place in an office or a meeting room, a boardroom, and as opposed to a courtroom. And everybody sits around the table with their counsel present. The witnesses are sworn in by the arbitrator. A court reporter is not required, and a court reporter is often not present unless both of the parties determine that that's what they want for some particular reason. And the rules of evidence are relaxed, so there's more flexibility. And what I mean by that is that the parties are able to bring the evidence to the arbitrators and present the case the way they would like to. And the arbitrator has the experience to parse out what's relevant and what's important to deciding the case. Whereas in court, the rules are stricter because the judge has to make the decision, what should the jury hear, who doesn't have the experience that your arbitrator has. So all of these things work together to reduce the level of tension in resolving the dispute. The second thing I think is important to consider is who resolves your dispute. In court, the judge will be assigned to you, and the judge is a bit of a generalist by necessity, right? Because the judge has to look at all different types of cases throughout his docket or her docket. In arbitration, you can choose your arbitrator. You can provide in your arbitration provision that the arbitrator has specialized knowledge in resolving complex business disputes or has knowledge regarding technical issues that are involved in your business. And if you use the American Arbitration Association for this purpose, they actually pre-screen arbitrators. And I think probably, Catherine, you could describe to them better than I can how the selection process works.
Yes, thank you so much, Sherry. So I also manage cases in my capacity as regional vice president, and I'll be hopping on a call later this week with my parties and for an administrative conference call. And my first question to them, sorry, we have a police officer coming by. But my first question to them is going to be, what do you want in your list of 10 panelists? So it's not always a list of 10, but typically, in this particular case, it will be. And so I'm going to say, what background do you want in your list of 10? Do you want retired judges? No problem. Do you have a really specialized dispute like Sherry just alluded to, something like cryptocurrency, right? So Sherry mentioned, judges are generalists and oftentimes, and so that same judge who's handling, who could be handling your cryptocurrency dispute could also be hearing family law matters, could also be hearing criminal law matters. What if it was important to you to have somebody with that specialized knowledge in crypto? I could pull a list of 10 people in your state with your venue, that specialize in that area. Of course, that's not the case everywhere, but in Chicago, that's not a problem. In Hawaii, that may be challenging to find 10 crypto experts, but so it depends. But the point is, I have a large database of people to pull from. I get to, based on the party's desire, select people that have those specialties and put them on the list for the parties to rank and strike or decide, which person they want from that list. And in the circuit court system, for those that haven't been a part of it, it's what my daughter's preschool teacher used to always say: you get what you get and you don't get upset, because that's just the way it works. You're lucky if you get one substitution of judge. And so, depending where you're at, of course. And so I think it's a really beautiful thing. I imagine how, I worked in the crypto world for a little while, how difficult it was for me, how long it took for me to get up to speed in that arena. And to think, if you had a complex dispute involving cryptocurrency, do you want someone whose first question is going to be, what is crypto? Think about that education learning curve there for that person deciding your dispute. So I think we have a beautiful wide range of panelists. They're international. They have all kinds of different specialties. And that's something that makes AAA stand apart from other ADR providers. So with that said, Sherry, are there any other factors to consider, things like confidentiality or venue, things like that make arbitration potentially a good option?
Yes, definitely. You mentioned confidentiality. That's another factor to look at and decide if that's important to you. Because in court, the decision is public. Anyone can access filings or come to court and observe what's happening. A recording of the proceedings is required in court. Arbitration is different in that way. Arbitration is confidential, meaning the proceedings are not accessible to the general public. The decisions are not published. And with social media today, frankly, I've seen this issue of confidentiality become a more important consideration to the litigants. The other issue to think about is venue. What I mean by venue is it important to you where the hearing takes place? In court, the court must have personal jurisdiction over the parties, meaning if you're in a dispute with a consumer or a vendor and they're in Ohio or Indiana or in California, you might find that that is where you are in litigation, that the court could determine it doesn't have jurisdiction over that party. By contrast, in arbitration, venue is wherever your contract says it is. So if you say in your contracts that you want arbitration in the event of a dispute and it's going to be in Michigan, then that's exactly where it's going to be, which is a great assurance to certain businesses. Secondly, there's a greater ability to handle arbitrations virtually now. We've done a lot. I've done entire arbitrations that we've done remotely, and they work beautifully now. I think everybody's more used to it. And that is something, that's an option that's not available in court so much. You can also, if you have a particular witness, you might have a live arbitration where we're all sitting around that table, but we can bring in a witness virtually. And that's done all the time now. And the arbitrators now generally have a great deal of expertise, and it goes very smoothly when we do this. So it's nice to have that flexibility. The other issue I do want to discuss with you today is cost. And I don't think I have to ask anybody out there if that's important, because I know it is. And let me say, at first blush, court has typically a lower filing fee to get in the door to file that dispute. And the judge comes with, so you're not paying for your judge. Whereas typically in an arbitration, the parties will split the fees of the arbitrator. However, I believe that it's too simplistic to just stop right there, that you need to consider that the arbitration is going to be quicker, more quickly from the filing of the complaint to resolution. In arbitration, you can expect 3 to 5 months, maybe a little more, maybe a little less, versus in court, you can expect 1, perhaps 2 years is not uncommon. And the reason for that, part of the reason, is that in arbitration, we streamline the discovery process. If any of you have been in litigation, you know what I mean, how that can get drawn out. In arbitration, documents are freely exchanged, but there's less written discovery, there's fewer depositions, motion practice is limited. If there's an issue, typically you let the arbitrator know, and a phone call is set up, and we get the issue addressed right away. And those are some of the reasons why we're able to get to a resolution faster. There is also, by the way, for smaller matters, which may be relevant to a lot of you who deal with customers, for instance, all the time, a flat fee option with the AAA. And Catherine, do you want to explain what that is?
Yes, thank you so much. We do have expedited cases. In those cases, they're even more streamlined than the regular, AAA rules. Discovery is very basic. Typically, there's no motion practice permitted. The hearings typically do not exceed 1 day, and they take place within 60 days. Think about that. That is fast. And then the arbitrator has 14 days to render a decision. So that is lightning fast compared to some, some circuit courts are more crowded than others. Sherry and I, as practitioners, everyone's heard that nightmare story of, the one that comes up. I had a case one time pending 7 years. I had, a colleague of mine had a motion for summary judgment pending in the state of California for 5 years. By the time that motion was decided, witnesses had passed away, things had happened, and lawyers had left the law firm and so forth. And so our rules are designed with those deadlines in mind, particularly for these smaller expedited cases. Because we know, business owners, small disputes, people need to get back to business, right? Focus your time on growing your business and not on expending a lot of time and money in a court system. So in a sort of a traditional court system, again, depending where it is, there are certain court systems that are just more backlogged than others for various reasons, volume and funding and things like that. But so Sherry, what about, tailoring the process, or, some issues around finality of the we don't use the word decision, we use the word award, right, in the ADR world. So what are some issues around finality of the award?
That is one difference between a resolution in court and a resolution in arbitration. In court, there is an absolute right to appeal to the Court of Appeals, which can be a valued right to have. However, what comes with it is also another 1 to 2 years before you get a decision on that appeal, and extra cost. And when I say cost, thousands of dollars to get that appeal written and argued before the court. In arbitration, by contrast, the right to appeal is extremely limited. In cases of fraud or misconduct, which are very rare, you may have an appeal, but it's very limited. And in fact, you can provide that the arbitrator's decision is final and cannot be appealed. So we've got a difference there. Let me just say in summary, courts are built to handle all types of disputes. It's kind of a one-size-fits-all operation. And courts do favor arbitration provisions, and they will enforce them. Arbitration, on the other hand, allows you to tailor the dispute resolution process. If you are interested in a arbitration clause, there's a couple of ways you can go about it. You can consult your attorney and develop provisions that work for your business. Another option, and a less expensive option, the American Arbitration Association now has a wonderful online guidance program called Clause Builder, and they can help you to do that. And Catherine, I see you shaking your head up and down at that. Do you want to describe that more specifically?
Yeah, I would be happy to. Yeah, and before I do, I hope you will have seen its pros and cons. It's like what Sherry said, not a one size fits all. You know, as small business owners in Michigan, you all know your business best, and you actually know before you enter into these contracts where the situations might turn left, or where there might be a dispute later on down the road. So you'll have to make these decisions evaluating all the pros and cons for yourself to see if this alternative system is the right fit for you. But if you've made that decision that it is, and many companies, international, small, you know, all different shapes and sizes have made this decision. And if you've decided that you want to start incorporating these clauses into your contracts, a great place to start is www.clausebuilder.org. And this is something that AAA put together to sort of help people see all the various options that you can put in. So, I mean, back in the day, it used to be like, just put a AAA clause, but actually now we're putting the resources there. So if you just hop on there are probably 15 standard arbitration clause options to choose from. Things like number of arbitrators, arbitrator qualifications, governing law, discovery, remedies, confidentiality, things like that, and potentially an internal appeal option as well. And the one that I want to just highlight, because, you know, I watched the show Suits, and there's a particular episode where the other side very intentionally buries the main character with boxes and boxes of discovery, knowing that there's no way, thinking that there's no way he would be able to get through that. And what were they trying to do? They were trying to bog him down. They were trying to distract, you know, from his time doing other things in the lawsuit and so forth. If you go on that clausebuilder.org, you can literally change the discovery for a potential dispute ahead of time. So for example, one on there right now is if the dispute is less than X dollars, then there shall be no discovery other than the exchange of documents. Think about that. So if you're like, okay, you know, I'm dealing in volume, whatever it is, and I know most of my disputes are going to be under $10,000, and I don't want to be bogged down with these massive discovery requests coming from 17 different areas, you can actually you can take our streamlined versions and you can further streamline them yourself. And so when you enter into contracts with your vendors and other people that you do business with, you can address those on the front end, which can really potentially save some time and money. So I really like that discovery feature one. So with that said, I see that we are down to just a few minutes left. Sherry, did you have any concluding remarks for us today at today's webinar? I think you did a great job, and it's really my honor to showcase practitioners in Michigan like Sherry that are working with small businesses every day. She is the type of person, right, who could be pulled to decide your dispute. And so we look for characteristics in people like Sherry, and that's why we picked her to feature today, because we think she'd make a wonderful adjudicator of a decision. And she's based locally. And what I love about Sherry is she's still practicing law. This isn't someone that's, been removed from the practice for years and years and years. She's in it. She's in it every day. And that gives her valuable perspective. So thank you so much, Sherry, for coming. Did you have any concluding remarks for us today?
Oh, well, thank you for that, Catherine. And I think I would just like to say to all of you listening to this is whatever you choose, giving it some thought now can greatly reduce the stress, the time, the expense later, and ultimately give you more satisfaction with the process. And as I said at the beginning, that's what I hope that you can all gain from this. So I hope this has been helpful today and that I've given you some things to think about. And thank you for listening.
Yes, thank you so much, Sherry. And just one more thing that I realized we didn't touch upon is mediation. So AAA also does mediations. You can incorporate them into your clauses as well. And actually our roster of mediators is open to the public. So if anyone wanted to see, the types of panelists we have as mediators, you could go to our website. But mediation is another alternative. You can put a requirement that the parties mediate before they arbitrate, which is just a process where the parties sit in a room with a third party. Typically, it's not the same person as the arbitrator. It's a trained mediator, and that person kind of helps the parties come up with their own means of resolution, right? And it's not something forced upon you, but it's somebody who's trying to help the parties reach, that negotiation and come up with a path forward that both parties are okay with, outside of someone sort of forcing something on you as a judge or an arbitrator would, to say, here's my final decision and that's that. This is the party saying, well, here's what I'm willing to do. Okay, I'm willing to do that, right? So we do a lot of mediations as well. And I think they're really a wonderful way to, again, preserve those relationships, save time and money. So I did want to put in a plug for mediations. And to the SBAM community, we're going to be doing more of these webinars in the coming months. So if you want to learn more, I encourage you to continue the conversation. Come on down to the next one, and we'd love to see you at more of these. If you had any questions or concerns, please let me know. I see Sarah's put that clause builder into the chat feature, but feel free to reach out. I could be reached at glowdk@adr.org. And thank you all so much for your time today.
Yes, thank you both so much. I thought that was very informative and certainly is going to get people thinking about these alternative options that they have. We will be sending this out to those of you who joined us live. If you're watching this on demand, you can just search for arbitration on the website to find additional content. And we look forward to welcoming you at our next webinar. I hope everybody has a wonderful afternoon.